Nervous shock can be defined as a psychiatric illness or injury inflicted upon a person by the intentional or negligent actions or omissions of another. And this kind of injury or illness is normally triggered. It is triggered off by witnessing an accident. For example, injury caused to one's parents, injury caused to one's children, or injury caused to one's spouse. Now, to amount to nervous shock, the damage suffered by the claimant must extend beyond grief or emotional distress to a recognized mental illness such as anxiety, neurosis, or reactive depression. Now, before a person can recover damages for nervous shock which he has suffered as a result of the defendant's negligence, he must prove all the elements. He must prove all the elements of the tort of negligence. And these are: 1, he must show that there was a duty of care on the part of the defendant not to inflict nervous shock upon him. Number 2, that the duty of care was breached, that is, the defendant's actions or omissions fell below what would be expected from a reasonable person. Number 3, he must also show a causal link between the breach of duty of care and the nervous shock or the psychiatric illness. You can also say that the claimant must show that the nervous shock was a direct consequence of the defendant's breach of duty. And lastly, it must be shown that the nervous shock was not too remote a consequence of the breach. So, before a person can succeed and recover damages under this tort of nervous shock, you must show all the above elements. Now, there are different victims of nervous shock. We have about 2 major victims of nervous shock. 1, we have the primary victims, and 2, we have the secondary victims. A primary victim is a person who is physically injured person who has been physically injured either in an accident. Okay, these are people who are personally involved. For instance, people who are physically injured. Earlier, a long time ago, rescuers used to be recognized as primary victims. However, today they are no longer recognized as primary victims. That is after the case of White versus Chief Constable of South Yorkshire Police. This is a 1998 case. Here, court said that since none of the rescuers were at the time exposed to personal danger or reasonably believed themselves to be, they could not be considered as primary victims. This is a case where police officers who were present in the aftermath of the Hillsborough disaster sued for post-traumatic stress disorder, and that was the holding of the court. But initially rescuers used to be recognized as primary victims. Look at the case of Chadwick versus British Railway Board. Here, court ruled that such helpers here, this is a place where somebody went to rescue, and court ruled that such helpers as primary victims of the accident could recover the damage caused by nervous shock in the same way as personal injury. So this case is much earlier than the case of White versus Chief Constable. And the case of White versus Chief Constable changed the law in relation to rescuers. So a rescuer cannot recover as a primary victim. And the second group, the second victim, or the second category, these are secondary victims. A secondary victim is a person who suffers nervous shock without himself being exposed to danger. For example, a spectator at a car race who witnesses a terrible accident caused by negligence on the part of another. However, court has limited the number of people who can sue as secondary victims, because there would have been so many people. Whoever witnesses an accident would have been able to claim for damages for nervous shock. So court has laid down a number of rules for a person to qualify as a secondary victim. He must show the following. He must show that he witnessed a shocking event with his or her unaided senses, such as being an eyewitness to the event, or hearing the event in person, or viewing its immediate aftermath. That is, that the person was in close physical proximity to the event. Okay, the person must have been in close physical proximity to the event. So this excludes events witnessed by television or informed by a third party. Number 2, for a person to qualify as a secondary victim, they must show that the shock was sudden and not gradual. Number 3, they must also show that the nervous shock was caused by witnessing the death or injury of another person who is in a close proximate relationship with that other person. And these kinds of relationships are usually described as a close tie of love and affection. And such ties normally exist between parents and children, or between spouses, or between fiancés. So in these kinds of relationships, parents and children, spouses and fiancés, there is a presumption that there is a close tie of love and affection. However, in others, like siblings, this tie of love and affection must be proved. And number 4, it must also be shown that it was reasonably foreseeable that the claimant would suffer. The claimant or a person in the claimant's position would suffer psychiatric damage or nervous shock. Okay, in these cases of nervous shock or psychiatric illness, it doesn't matter if the claimant was a person who was likely to suffer from psychiatric illness or a person who was susceptible. It is like saying somebody who is likely to suffer from an asthma attack, because they already have asthma, okay? And then they suffer it as a result of somebody's negligence. Okay, that is what I mean by that it doesn't matter that the claimant was particularly susceptible to psychiatric illness, because the defendant must take his victims as he finds him. The defendant must take his victim as he finds him, or pay for all the consequences of nervous shock. This is referred to as the eggshell skull rule. Please read it. The eggshell skull rule. Egg and shell skull rule. Okay, I'll give you some examples of cases of nervous shock. One of the cases is Hines versus Berry. Here, The plaintiff was out for a drive with her husband and 4 children, and on the way they stopped for a picnic. The plaintiff crossed the road with 1 child to pick blueberries. A car driven by the defendant was out of control and it crashed into the van where the plaintiff's husband and her children were making tea. On hearing the crash, the plaintiff turned. The plaintiff suffered nervous shock on witnessing the events, and court held that she could recover damages. Thank you very much for listening. Thank you.